If you have colleagues that weren't able to be here this morning, we'll share out the YouTube video link later today. But I'm going to go ahead and let Sinead take it away.
Great. Thanks, Natalie. Hi, everyone. My name is Sinead McCarron. I am a Deputy District Attorney here in Contra Costa County. I've been with the District Attorney's Office since 2019, and I currently work in the Felony Domestic Violence Unit. Right now, in particular, I'm stationed at the Family Justice Center in Richmond. And in addition to having my own caseload, I also review cases that come in as felony domestic violence cases for filing. So I'm sure no one wants to hear me talk for the full hour and a half that we have. So if you ever have any questions at any time, feel free to put in a question, a chat, whatever, and I'll try and look down and make sure I'm paying attention and answer it. Or Natalie can kind of wave at me and let me know.
I'll flag it for you.
Thanks. Okay, so I'm going to start sharing my screen here. See if this works. Are we good?
That looks great.
Okay, great. So the purpose of today's webinar is really to just try and understand the basics of what is criminal law and what happens in the criminal justice system when a case gets filed. So the first step that's important to know is, well, what is criminal law compared to, a civil law case? Well, criminal law is a system of laws that's concerned with crimes and the punishment of individuals who commit crimes. Another way to say this is that criminal law is acts in which a court of jurisdiction has the power to sanction or sentence with a punishment to include physical custody or incarceration. Criminal law is the only type of crime or law where someone could be punished by putting into physical custody, whereas it's civil, it's typically monetary damages. This is different because in civil, it's two parties, like a person versus a person, disputing their rights, whereas in criminal law, it's a process that involves the government deciding whether to punish an individual for a crime. That's why when you see like criminal cases, it will always say people versus individual's name, not person versus person. So in order to get to a crime, there is a body of laws that tell you what a crime is. There's two types of bodies of laws. The first is Title 18 of the United States Code. That's what determines what are federal crimes and the criminal procedure for federal cases. In addition to federal, every state has their own code section. In California, it's called the Penal Code. So every county in California, so by me working for Contra Costa County, what I abide by is the California Penal Code. And each state has their own penal code section. So states can vary in laws, which I'm sure we all know from watching the news that various states will randomly put different laws into place that, would never pass or fly in California. Now, generally, there's two types of crimes and two levels, misdemeanors and felonies. Misdemeanors are typically considered the, I put in quotations, less serious crimes. And the only reason they're really considered less serious, because every crime is serious, especially to a person that was affected by a crime, it just means that the penalty that someone can face is a lot less. For a misdemeanor, the max amount of time someone can receive is a year in county jail. So they would never go to prison for a misdemeanor. Or you could be put on some type of court probation, which is less restrictive and much more, for lack of a better term, casual than a felony probation. Felony crimes are considered the more serious crimes. Those can include a prison sentence, a formal probation, which is where you have to check in with a probation officer. Typically, you're hindered from doing a lot more things, and you're prohibited from owning firearms. Also, while you're on felony probation, you can't vote. Up until recently, if you were ever a felon, you couldn't vote at all, but there was a law that changed a couple years ago That said, if you're off felony probation, you now get those rights restored. But with a felony conviction, you lose a lot more of your rights than if you're convicted of a misdemeanor. So when a crime occurs, you might be wondering, how does a case get filed? Well, first, obviously, with the first little crime scene tape, a criminal offense has to happen. There has to be some type of crime that happens that's a violation of the penal code. From there has to be a police report that's made for the crime, because the district attorney's office will never know a case or a crime happened unless it's reported to the police. When a case is reported to the police, that officer, the investigating officers, the detectives involved, will write a police report. Those police reports are then given to the district attorney's office to review. Once the district attorney's office receives a police report, that's when the review process goes to decide whether or not to not file charges against that person or to continue and file charges. Now, you can say, who here, or raise your hand or type in the comments, has watched like those Law and Order SVU, CSI types of shows, and they're always talking about the victim pressing charges. What do you guys think? Do you think a victim presses charges in a case? Yes, no? Well, most people will think, yeah, a victim is the one that's involved, so he or she obviously is the one that's going to decide whether or not to press charges. And police officers always ask people, do you want to press charges, right? So it's their decision. Well, that's actually a bit of a misnomer, because ultimately it's up to the district attorney's office on whether or not to file charges. Because when you look again at that criminal case, it says people versus an individual. It's not person versus person, because it's the government that brings charges against someone. Obviously, it's helpful if a victim of a crime wants to press charges and is cooperative with investigation, but that doesn't necessarily always need to happen if the district attorney that's reviewing the case finds that there's enough evidence and it's important enough to proceed. Whether or not a person wants to press charges is not necessarily always important. So going from there, what does a prosecutor consider when filing charges? And I'll probably switch back and forth between using district attorney and prosecutor because they mean the same thing. So the two main things to consider when filing a case is, first, obviously most important, the evidence of the crime, and two, a person's prior criminal history. That kind of goes to, is it the right thing to do? First, evidence from a crime. This is pretty obvious, and I'm sure all of you that have watched crime shows know what evidence from a crime can be, right? It's eyewitness testimony, what people saw, what they heard, what they tell police officers. It can be DNA, it can be fingerprints at a scene, 911 calls, video footage, text messages, phone beeps if someone's like tracking their phone. It can be lots of things. When it comes to prior criminal histories, what's first considered is what's called a rap sheet, which is shorthand term for records of arrests and prosecutions. So whenever an individual is arrested, that arrest is put on their rap sheet. It will usually say on their rap whether or not that case was actually prosecuted or if no charges were filed. From knowing what a person was arrested for or what they were prosecuted for, then you can look up that police report based on that arrest to see what that prior crime was about. Also on the rap, you can see whether or not that person was convicted of a crime, what type of crime, and what type of sentence they received. So let's say someone was arrested for domestic violence battery, and you pull up their rap and you see they've already had 7 arrests for domestic violence battery, and on one of them there was a conviction. That might be important to see hey, there's a pattern. This isn't the first instance. We need to take a bigger look into this. Also, it's hard since I work in domestic violence. I feel like I tend to go that way more because that's more my specialty. But restraining orders are also important to look at too. So in addition to a rap, you can look up and see whether or not someone is either the restrained person to a restraining order or a protected party. And that's important to see if another law was violated, such as a restraining order violation or something like that. Now, also, why prior criminal history is important is because it can affect the type of evidence that comes into a case. This relates to the 3 evidence code sections, 1101, 1108, and 1109. Now, typically in a criminal case, you cannot use the argument of, well, they've done it before, so that means they've done it again, because that is improper character evidence and improper propensity. But it's different for sexual assault and domestic violence, which I'll get to that in a second. But under 1101, if there's a prior crime that's similar, you might be able to argue that it can be used to show someone's motive, opportunity, intent, ID, knowledge, or lack of mistake. But you can't use the prior to say, hey, they, committed theft before from this target, so that means they committed theft this time. And I think the reason why you can't say that is obvious, is because if a case goes to a jury trial, you want to make sure that the jury is evaluating the evidence of the specific crime and not punishing someone for something that they did in the past. Section 1108 refers to sexual assault cases, and 1109 refers to domestic violence cases. Because the nature of sexual assault and domestic violence is different than most other crimes, you actually can use someone's prior criminal history of sexual assault or domestic violence as propensity. Legislature carved out a special exception for this. I imagine it's because there's been many studies that show when someone is people can be repeat offenders of domestic violence. So if they have prior arrests or prior convictions, you can use that argument if the court lets you to say, hey, they were arrested for this offense before. That's evidence that they committed this current offense that they're charged with. One of the other important things a prosecutor considers is the burden of proof that has to be met in a criminal case. Just really quickly, does anyone know what the burden of proof is in a criminal case? It's said often in all those types of crime shows.
Feel free to put it in the chat. Oh, somebody said proof beyond a reasonable doubt.
Yes, that's it. Magic words. I was kind of expecting someone to say proof beyond a shadow of a doubt, because I hear that very often too. And I think that a lot in movies, but it is, that's exactly right. It's proof beyond a reasonable doubt. It's the highest burden in all of law. And we don't like to put percentages in law. It's probably because we're all very bad at math, but if you were to put a percentage of it to it, it would be like 99%. That's very different from a civil case, because civil cases typically are preponderance, which is, I would say, like 51-49. So like if there was a case that Apple was suing Google or something, they have to just show more likely than not that they're right and Google's wrong. Whereas in a criminal case, the burden's a lot higher than that. And that's important, right? Because you're dealing with someone's liberty. So it should be that high. So even in reviewing police reports and deciding whether or not to file charges, you might be looking at a case and it's like, did this person do it? Yeah, probably, but probably is not good enough for a filing, because we're always thinking about our burden of proof and what we're going to have to show to a jury to ensure that we can prove this case beyond a reasonable doubt. Now, is everyone on board so far? I'm probably talking very fast, so sorry. Now, when a case is finally decided to be filed, there's 3 different words that you'll see about what that piece of paper that's filed is called. That is 1, a complaint, 2, an information, and 3, an indictment. Now, a complaint is the very first piece of paper of what the prosecutor, the district attorney, files with the court. In misdemeanors, this is all you'll get, but in felonies, there's a couple more steps. In a felony, after a person is held to answer on charges at a preliminary hearing, which is something we'll discuss in a couple minutes, then the piece of paper is called an information. If you see the word indictment, that means instead of a preliminary hearing, the person was held to answer on charges through a grand jury. In our county, I can't really talk to other California counties. We mostly do only preliminary hearings. I think that's pretty much how it is across the state. On the East Coast, they do a lot of grand juries. So if you've been hearing cases with former President Trump or other, big East Coast cases, you'll hear the word indictment a lot, like, oh, they were indicted on these charges. That just means it was a grand jury, but it's the same piece of paper as an information. Now, what's on this piece of paper? Well, that's probably obvious, but these pieces of paper, the complaint, information, indictment, contain the list of charges a person would be charged with. On the screen is an example of what our complaints, informations, indictments would look like in Contra Costa County. The example I have up is for a domestic violence offense, but on the first part of the page, it will say the defendant's name and date of birth to ensure that the person that's being charged, that it is in fact that person, so it's not a case of wrong identity. To the right of that, there will be all the penal codes that are being alleged to be violated. And then underneath that, in the body of the complaint and the information, it will state the specifics of those penal codes. So it will always state who the victim is. If it's a domestic violence or sexual assault case, it will typically be listed as confidential victim or Jane Doe, or for minors to protect their identity. It will state what date the offense is, so the individual that's being charged knows what date we're talking about. And then it will state the type of crime, the explanation of the crime, and then what county it happened in. And this is required because a person that is charged with crime is required to be on notice of what they're charged with. So essentially, they're not blindsided by what they're being charged with.
Sinead, we have a quick question in the chat and it relates to sort of evidence, so I wanted to flag it for you.
Yeah.
So somebody asked, why would the district attorney or police listen in on phone calls of potentially innocent people who weren't associated with the crime, but may know the people who were accused of committing the crime?
Sure. So that's a little bit of a complicated question. It's not something that's necessarily in my wheelhouse. That happens a lot in gang investigations. But there could be what's called wiretaps, where officers listen in on people's calls to try and obtain information about a crime. But in order for an officer to do that, they always have to have a warrant signed.
Okay.
So if someone wants to do that, they have to show what's called probable cause to a judge for a judge to give them permission to do that.
Gotcha. Thank you.
Yeah, same thing what's called pinging a phone. So if an officer wants to ping someone's phone to try and find their location, very rarely happens, but if it does, they always have to get permission from a judge. They can't go and just do it on their own.
Got it. Thank you.
So now that we're in court, you might want to know, well, who's all involved in the system. Well, on the prosecution district attorney side, there's typically 3 main people or 3 main groups. First is obviously the police officer, detective, police agency that investigated the case. Then there's obviously the district attorney / prosecutor, and that's the individual that is assigned to prosecute that case in court. Next, depending on the type of crime, there's always a victim advocate that is assigned to our cases. Now, our victim advocates are honestly probably the most helpful and best people in our office. They help at victims kind of know the criminal justice process system a little bit. It's kind of there to hold their hand and help them through the process, let them know about resources that are available, and are really just there as their support person. Even if they have other people, it's helpful because a lot of times prosecutors workloads are so heavy that they can't give the individual attention to a victim that they deserve as they go through the process. On the defense side, there's always typically a defense attorney. As in the United States, everyone has a right to have an attorney, even if they can't afford one, one's appointed to them. And I can say our public defense bar in Contra Costa County is very good. There is a lot of really, really great attorneys on the defense bar. I'd say probably 95% of the cases usually are with a public defender or alternate defender or a conflicts attorney or something like that. Otherwise, there's private defense attorneys too. Also on the defense side, there's typically private investigators. Sometimes these can be individuals that are retired police officers or did some type of prior investigative work. And what their private investigators will do is they often do their own type of investigation as well. Even though in a criminal case, defense attorneys and defendants do not have to prove their innocence, right? Because in our country, it's you're innocent until proven guilty, and the burden is completely on the prosecution to prove the case. But oftentimes they'll still want to do their own investigation. So they'll have their private investigators reach out to witnesses, victims, other people that might have been there and gather their own information. On the court side, there is always a judge that's assigned to every case, and that judge is there to be the impartial, for lack of a better term, referee for the case. They make rulings about what can come into evidence, and ultimately, post-trial, a judge would be the one to sentence the individual. Also in the court system, there are probation officers, and probation officers are when someone is placed on probation, which we'll discuss in a little bit. These are the individuals that people convicted of crimes will be checking in with after they're placed on probation. Now,
Hey, Sinead, we have one quick question because you were mentioning the victim advocates and how amazing they are. And in every county, victim advocates are critical. Somebody said, how does a victim get a victim advocate assigned to their case?
So I can't speak for other counties, in our county, if there's a victim listed in a case, which most do have victims, unless it's like Target or something that gets vandalized or stolen. A victim advocate should automatically be assigned at the time the case is filed.
Okay.
Usually Shannon Mahoney is our #1 head of victim advocates. She gets a notification when a case is filed, and then she assigns them out. So
Gotcha.
it should be assigned from the very beginning, and then either the attorney that's assigned to the case will let the victim know who their advocate is, or the advocate will reach out separately, either through a phone call or will send something in the mail.
Gotcha. Thank you.
Yeah. So now that a case is filed, from start to finish, when we're in the courtroom getting the case going, there's 5 main, I guess, roadmap points from start to finish. That's the complaint, the filing of the complaint, which we just discussed what that is, an arraignment, a preliminary hearing if it's a felony case. If it's a misdemeanor, there's no preliminary hearing and there's no arraignment on that information. But there is felony after the preliminary hearing. There's another arraignment on what's now called the information. And then the last step is to either go to trial or for the individual to plead their case out. First, starting with the complaint, again, we went all over that. It's that piece of paper that's filed with the court that says basically, hey, court, we the people think this person committed this offense. We want them held responsible for these crimes. The next step after a complaint is filed is what's called the arraignment. Now, if someone is, if a complaint is filed against a person who is in custody and they're on a felony, they have a right to have their preliminary hearing with the arraignment within 10 court days or 60 calendar days. If an individual is out of custody, they don't necessarily have that 10 court day right, because they're out of custody, so they have a little bit more free liberties than someone that's in custody. Usually at arraignments, it might be different in different counties, but in Contra Costa, individuals will always plead not guilty and then either set their case time not waived, which is within the 2 time constraints I just mentioned, or time waived, which means their case can kind of be set on whatever timeline they please into the court's availability. The next step after the arraignment on the complaint, if it's a felony, is a preliminary hearing. Now, a preliminary hearing it's not a trial, it's a lot more informal and it's a lot shorter. And that's because the burden of proof at a preliminary hearing is much lower. The people just need to show that there is a strong suspicion that the charges are true. And those are one of those legal words where it's like, what does a strong suspicion mean? It's kind of like more likely than not. So because it's meant to be a lot shorter than a jury trial, for example, like a case that could take maybe 3 weeks in a jury trial would take maybe 2 hours in a preliminary hearing. You're only showing the basics of your evidence of what you think you have to prove the case. And you're really just kind of giving the judge a preview to show, hey, is there enough evidence here for a jury to convict the defendant at a felony trial? The reason these also are a lot shorter than jury trials is because one level of hearsay is allowed. Now, hearsay is also one of those legal terms that's thrown out there a lot, and hearsay is just an out-of-court statement being brought into court for the truth of the matter asserted. Typically, hearsay is not allowed in court unless there's some sort of exception. And that makes sense, right? You want to hear it from, for lack of a better term, from the horse's mouth. You want to hear it from the person who specifically witnessed that, what they saw. You want them to be able to be cross-examined about their statement. But in prelims, it's a little bit different. A qualified detective or police officer, which any officer that went to the post academy, basically their training to become an officer, can testify in place of victim or witness to one level of hearsay. And this is so you don't have to bring in 20 witnesses to say the same thing, when at prelim an officer that interviewed all those witnesses can come in and testify about what those people said. It's way just to speed up the process, because if we didn't, it's called Prop 115. And if we didn't have Prop 115, our backlog would be probably 10 times worse than it already is now. Now, after the preliminary hearing, if an individual is what's called held to answer, which is another fancy way of saying the court finds that there's sufficient evidence for that charge, then there can be an arraignment on an information. So once someone is arraigned on an information, they can either set their case, again, time not waived or time waived. If a person sets their case time not waived, then the trial must start within 60 days of their arraignment. So 2 months by their arraignment. If that happens, typically a trial is set about 4 weeks out, and then both parties kind of have to prep up for trial, try and work on negotiations, or if they think the case is not going to resolve, they have to proceed and have a jury sworn in by that 60th day, or the case gets dismissed because you're violating that person's speedy trial rights. Or if a person does not go time not waived, they can set their case time waived. That means that they don't want their trial right away. They want to take time to maybe negotiate the case, gather more evidence, things like that. A person can always later down the road, what's called pull time, which means, okay, I want my trial within 60 days of my next court date. So then that starts the clock again. So once someone waives time for their trial, doesn't mean that it's always waived. They can always, take it back and then set their case on a time not waived basis. The last step then obviously is either a trial or a plea, which I'll talk about in a second. So seeing these 5 main points, you might be thinking, you know, wow, like a criminal case, it must go through the court process really fast if these are the only 5 steps you have to take, right? It's speedy. Unfortunately, it's not. Oftentimes between each of these big points in a case, there's what's called settings. This is basically check-ins with the court to see how the case is going, how settlement discussions are going, things like that. When a person waives time in their case, the cases can drag on, unfortunately, for years. For example, I have a case that's set for trial next week that's from 2020. It's a very old case, and it's frustrating, especially for people that are involved in the case. But the fact of the matter is, defendants in cases are the ones that control the clock in their cases. And thinking it from a perspective, if you had a family member that was charged with a crime, you would want them to be the ones because that's their life that's being affected. But if you have a judge that's impacted, they have a heavy caseload, and they're not too worried about the case getting to trial or resolving, a case can age on and on and on. There's only so much that the prosecutor or district attorney can do to get a case resolved. It really does depend on the clock that the defendant sets in the case.
Sinead, we have a couple questions for you. One of them, I'm not sure that you'll be able to answer because this might be really case specific, but I think it's related to looking at evidence when deciding whether to charge somebody with a crime. It says, why would charges not be pressed if there was clear evidence or an admission that a crime had been committed with regard to domestic violence and sexual assault? And you might be going over this in a little bit too.
Sure, I can go a little bit more in depth in that now.
Yeah.
So specifically when it comes to domestic violence cases, I can't necessarily speak for sexual assault cases because that's not my forte. But domestic violence cases in filing in our county, we have an even higher standard of filing than we do for any other type of crime. And I think that's just because the nature of the case. And we have a blanket rule from up top that if the case cannot be proven with circumstantial evidence, then it shouldn't be filed. Sometimes that might seem like really unfair because a lot of times domestic violence is he said, she said, he said, she said. But looking at it from a perspective, doing domestic violence cases, the unfortunate reality is that very many victims become what's called uncooperative, will refuse to come to court for a variety of reasons, whether that's to protect themselves because they don't want to put their person that they care about in jail, don't want them to be in trouble. Maybe they're feeling pressure from that person to not cooperate with prosecution. So if the only evidence that we have is that person's statement, without that person in court, the case can't be proven. So to take that pressure off of them, in order for us to file a case, we need to make sure that we have evidence that we could prove it, even if they don't want to show up for court. Which I think some counties are probably different. I think Alameda, I don't know if they prosecute cases unless the victim's cooperative. I can't speak to that because I don't work in that county, but that's just how our county is. So, and I know it's especially for people that are ready and they just, especially in DV, they just finally were able to open up about what happened to them and then their case doesn't get filed. And it might feel like someone's not believing in them enough to file the case, but it really is, for lack of a better word, a protection for them to try and, because our goal is to try and prove a case without them being there and without them feeling like the weight is on their shoulders.
Okay, we have, there's a couple of more questions that just popped up in the chat just from what you were talking about. Again, I think they might be a little case specific and you might be answering in the best legal answer possible, where it's like, it depends. That's the answer you always give, right? Or attorneys always give, well, it depends. But one person was asking about if a crime happened between a landlord and a tenant, would it be criminal or would it be like in civil housing? Or could it possibly go to both?
Yeah, I think it does depend on the case specifics of the facts. So if a crime occurred, let's say the landlord vandalized the tenant's property or something like that, that could put it in criminal territory. But if
Okay.
it's more civil based, where
They like filed an eviction or something.
yeah, I think that would
That's
be
gonna
more
be
civil because it's person versus person.
okay.
Yeah.
And then another couple questions was, I think these are all really gearing towards the amount of evidence you need to charge a crime and actually press charges. So somebody was asking about, the same thing happening in a child abuse case with a teacher abusing a student situation, and as well, if defendants are admitting that they've done something, why would a DA not press charges?
Again, that would be case specific for sexual assault cases, which is not my forte. That's Paul Smart office, who you may or may not have heard from him. He reviews all the sexual assault cases and child abuse cases. So I can't really answer that. I know that they do what's called pretext calls in sexual offense cases a lot to see if they can get an admission. And I think that helps towards filing a case. Also too, if there's several people that reported and they don't know each other, that's also evidence, but I'm not sure the specifics of what they do in sexual assault cases, unfortunately.
That's okay, thank you.
Yeah. Okay, yeah, so I described how unfortunately cases, they can go fast within a year, but most of the time they're dragged out with all these setting dates and conferences with the judge and things like that. So as the little picture shows, the wheels of justice can be quite slow and quite frustrating at times. So in cases, if they don't go to jury trial, they're typically resolved by a plea. And also it's not written on here, but a case could be dismissed ultimately. I don't think that happens too often because of how serious cases are reviewed before they're filed, but that's also a possibility besides a plea or a trial. When cases are resolved by a plea, saying that, yes, I committed this crime, there's two types, guilty and no contest. Really, they kind of mean the same thing. If you're ever in court and you hear someone say, I plead no contest, the judge will say, okay, I find you guilty. Really, the purpose of no contest is kind of for legal situations where they don't want it to say guilty on their plea form. An example I can think of is maybe for immigration consequences, things like that. They can't have a guilty plea. Most crimes do plead no contest in our county. I think that's just as kind of a CYA for the future. The only exception is typically for our sexual assault cases and our domestic violence cases, is that we do require a guilty plea. And that's really just for the victims that are involved and that are affected by these crimes, because especially if they're present in court when the plea is being taken, it's much more powerful and much more impactful for that victim to hear the perpetrator say guilty than no contest. So that's why we require guilty pleas in those types of cases. And of course, if someone does not want to plead guilty or no contest, they can always continue to plead not guilty and set their case for trial. Oh, before I get into trial too, the types of pleas and outcomes. So for a plea, usually if someone is not sent to prison, they are placed on probation. I described a little bit earlier what probation is when it comes to felonies, formal probation. That is more strict than what's called court probation, because on formal probation, a person has to check in with their probation officer. usually on like a bi-weekly or monthly basis. They can be subject to drug testing. Part of their plea might be that they have to go to rehab if it was an offense where clearly alcohol or drugs were an issue. Typically, they'll be subject to having no alcohol or drugs. They'll be subject to search and seizure, which means that if a police officer pulls them over and sees that they're on probation, and one of their clauses is that they're subject to search and seizure, they cannot refuse being searched. Typically, if someone's not on probation, you have a right not to be searched by an officer. So when you're on probation, that kind of liberty is taken away from you. On probation, you can also be subject to a stay away order from a particular location, or you can be subject to what's called a criminal protective order, which will order you to stay away from a specific person. Usually those are in our domestic violence, sexual assault cases. In addition to being placed on probation, which in felony land, it's usually for 2 years. There's some exceptions for some crimes. For example, in domestic violence, the law says it has to be a minimum of 3 years. Within that probation term, someone can have what's called a suspended state prison attached. That means that if someone violates their probation and they're found on that violation, state prison could then be imposed. This is kind of used as kind of keeping a hammer over someone's head to ensure that they stay on the right track, because probation, especially for felony cases, is considered a big break. So it's kind of like saying, hey, you're not being given a jail or prison sentence now, being placed on probation, provided you abide by all the terms, you'll be good to go. But if not, and you violate your probation, you could be looking at going to state prison if you're found in violation. In addition to probation, someone in felonies can also be sentenced to state prison. So if someone's sentenced to state prison, they can go anywhere in the state. It's not just San Quentin or the local prisons. I've seen Folsom, blanking on other names of other prisons now, but it doesn't matter where the crime is committed for prison. I think once they're sent to CDCR, the Corrections Department, custody facilities, I'm butchering that, but they kind of decide where that person is sent. The minimum state prison term is typically 2 years, but several felony cases can be served at what's called half-time. And if trying to get into sentencing laws right now, we'd be here for another 2 hours. They're very convoluted and complicated, but even if you see like 2-year state prison, majority of the time, the person's going to be there for less than a year. If a person gets a county jail sentence and is not sent to prison, they'll stay in local custody, either at the Martinez Detention Facility or at West County. The maximum county jail sentence will be 1 year. You can't do 2 years county jail. The max is going to be that 1 year mark. And then, so this is for felonies. For misdemeanors are considered our less serious crimes. It's typically court probation, which is, they would never get a suspended state prison on court probation because prison's only for felonies, but they can have the same type of terms that are attached to formal probation. It's just court probation, it's kind of more on the person themselves to make sure they're keeping up with what they're told to do. There's not going to be a probation officer checking in with them to make sure that they're keeping up with all their terms. Now for trials, if someone does not plead before going to trial and continues to say not guilty, I want my jury trial, that's the next and really the final step of the process. For trials, there's 2 types. There is a court, otherwise known as bench trial, and a jury trial. I would say 99% of cases are jury trials rather than a court trial. A court trial, there would be no jury. It would just be a judge listening to the evidence and making the decision on whether the people proved their case beyond a reasonable doubt. For a jury trial, there is always 12 jurors and typically anywhere up from 1 to 5 alternates in case one of the 12 jurors all of a sudden get sick, can no longer be there, etc. So you can keep the case going. In addition to the 12 jurors, who are the ones that ultimately decide whether or not the prosecution proved their case beyond a reasonable doubt, there's the judge, who is there to be, again, the referee of the courtroom to decide what's coming into evidence. They rule on objections. And if a person is convicted of the offense, they're the ones that are going to be doing the sentencing. Everything for jury trials is done in person. So again, it's not like a prelim where an officer can come in and testify about what an individual said. Each person that's involved in the case that's a witness has to be there, unless there's always the caveat, unless there's some sort of exception where you can get their statement in through a hearsay exception. And also the defendant has to be present for their trial. Also too, there's always caveats to that. There's been cases where defendants have waived their presence, but that is extremely rare and very rarely ever happens.
We have one question in the chat, and then I also have a question related to this. Why would you, as a defendant, prefer a judge-only trial versus a jury trial? Because you have that option to choose that, right?
Yeah.
Why?
Usually,
what would be the benefit?
The benefit would be like if it's a particular legal issue that they think a judge would be better at understanding, they might want a judge to review the case rather than a jury. A jury is typically better if maybe the facts are more on their side, or they think someone might get confused by the facts, or they think there's an element that's missing that's not proven that a jury would not convict on. But usually, like, say, like, I don't know, we can't even think of a case where there is a court trial because it's very rare, but say like the facts of the case are really, really bad, and you're worried that a jury's just going to hear the facts and hear the charge and just be like, I'm just going to convict this person because
it's like so emotionally impacting.
Yeah.
Got it.
Where if they're worried about that, but they think that there's a legal issue that can't be proven, they might think a judge is better on hearing this evidence and deciding it.
Okay. And then one of the questions, you might be doing this in a minute, but can a victim participate during the court hearings, whether or not they're subpoenaed? For instance, if they want to address the court, does the victim have the opportunity to do that?
Yes. So the best way for a victim to do that, if they want to address the court, whether it's for a variety of reasons, they're angry about the case taking so long, they want a criminal protective order modified, the best way to do that is to contact the advocate or the attorney assigned and say, I want to address the court about whatever issue. Then it can be put on calendar to give the victim a time to address the court. If it's day of, depending on the judge, if they're nice or not, on how busy the court is, they might be like, I'm not going to hear from you right now, come back next time. So that's the best way to address. Because I have had cases where victims have come in frustrated with how long the process is taking. Was like my first felony trial was like 2 years vehicular manslaughter, and the whole family came in to the judge and told the judge, this is taking too long, we really want a trial set, and the judge listened and made the defense get ready for trial. So it can be really helpful and impactful to a judge to push a case forward, because they see our cases every day, but when it's the person that's involved in the crime, that's going to make much more of an impact to them to listen to them rather than, you know, the attorney they see in there every day.
Right. And then in terms of the jury versus a judge trial, somebody just asked, does every county in California have that option?
Yes.
Okay. Thank you.
Yeah. So I'm sure you've all seen on crime shows, law shows, trial shows that they always put these trials up and immediately there's a jury that's there listening, opening statements, witnesses take 2 minutes, closing arguments are really impactful, and everything is done within 20 minutes or a day. I wish that was the case in real life, but the unfortunate reality is trials can take quite a long time. The first stage that most people don't know about what's going on behind the scenes is what's called motions in limine. I'm sure limine is a Latin term that I actually don't know what it means, but everyone knows motions in limine means rules of the road. So both sides, the prosecution and the defense, have to file these motions in limine with the court prior to the trial beginning. And typically the first day trial is set, you'll go over these motions. What these motions are requests to the judge for the rules of the case. They typically include a statement of facts about what you believe the evidence is going to show, the witness list of all the witnesses you intend to call, and then requests to the court for the types of evidence that you want in the case. For example, we talked a little bit back about the evidence code section 1101, 1108, and 1109. You can't just bring in those prior acts into court without asking the judge first. So that's something that would be put in a motion in limine to flag to the court, hey judge, I have this evidence of this prior offense that I want to bring into this case, even though it's not charged. Here are the reasons why I think it's relevant. Will you let me bring it in? And then ultimately it's up to the judge to decide whether or not they're going to let that type of evidence into the case. Also, a popular motion in limine might be trying to eliminate maybe mention of drug use or alcohol use if it's not relevant to your case, because mentioning a topic like that could inflame a jury, and then you're worried that the jury will either convict or not convict based off of sympathy or anger toward that certain topic, rather than focusing on the charges and the crime that occurred. This process is to try and help the court go faster during trial, so there's not so many objections, because this is when like all the objections are kind of done behind the scenes. Once the motion in limines are done, and sometimes they can also bleed into when jury selection is happening, but the next step is jury selection. I would say if you do a poll of people that are trial attorneys, I would say at least half, if not more, will say jury selection is their least favorite part, because it's so stressful and it's really awkward standing in front of a room of a bunch of strangers that are judging every word that you say. But jury selection is arguably the most important part of trial, because you're there to learn about people to decide whether or not they can be fair and impartial jurors in your case. And it's awkward sometimes if there's anyone that's been here on a jury. Sometimes it can feel a little invasive with the types of questions that are being asked, or sometimes the questions that are asked kind of seem silly, but there's very specific rules that we have to follow in jury selection. For example, we can't pre-try our case, so we're not allowed to talk about the facts of the case and be like, hey, this witness is going to say, you know, John Doe was blue. Are you going to have an issue with trusting what they say? You can't do that. You have to try and think of an analogy that's not trying your case and giving the jury facts about the case before they hear the evidence. And again, this all goes down to ensuring people can be fair and impartial to the case. That's why it's oftentimes really hard to pick juries for sexual assault, homicides, and domestic violence cases, because they bring up such strong emotions in people. But the goal is to find people, like, not to say that you can't have emotions, because we're human, we're allowed to have emotions. It's more so to ensure, can you set those emotions aside and really hold the prosecution to their burden of proof? So even though you hear these awful facts about what happened, if you don't think the case was proven beyond a reasonable doubt, could you still say not guilty at the end of the day, even if you feel bad about it? Things like that. Jury selection sometimes can take longer than the actual trial, depending on the type of case it is. And then once that's done, then there's what's called opening statements. I'm sure everyone knows and has heard the word opening statement before, but that is used to give the jury a roadmap of what each side thinks the evidence will show. This is not the time to argue the case and say, this is going to be proven by X, Y, and Z. You have to say the evidence will show, you know, yada, yada, yada. It's not the time to put in your own opinion. After opening statements, that's when the prosecution puts on their evidence, and evidence is put forth through witnesses. Witnesses will testify about what they saw, the type of investigation they did, exhibits will be admitted, all that fun stuff. After the prosecution puts on what's called their case in chief, the defense, if they want to, they don't have to because they don't have a burden, they can then put on their case. That could involve recalling some of the prosecution witnesses, they can call their own witnesses, things like that. After the defense case, either the case is done and it goes to closing arguments, or there can be what's called rebuttal based off of what the defense presented. So, and it can go back and forth. So say defense brings forth a witness and the people have someone that can rebut that statement, they'll bring that in. Let's say defense has someone that can rebut that person, that can be brought in. It can go back and forth like that. After all that's done and the case is closed and the evidence is all in, then there's closing arguments, which is considered like the fun part, because that's when you can argue, hey, this is all the evidence in the case, apply the facts to the law, and you're going to find this person guilty, or through defense, not guilty. That's when the attorneys can make their arguments for what they think the evidence showed in the case. The way the closing arguments go, because the prosecution has the burden, they go first in their closing argument, then defense goes, and then the people have the opportunity to rebut defense's argument after the fact. What the thought process of it is, they have the burden of proof. They didn't know what defense was going to say in their closing, so now they have one more opportunity to discuss the case with you. Once that's done, then it's in the jury's hands, and the jury deliberates and decides whether or not the charges were proven. Sometimes deliberations can be fast, sometimes they can take days. It just depends on how much evidence there is, if there's a disagreement about something, things like that. So there's never any timeline on how long a jury can take. And then the outcome, obviously, for trials is either guilty verdicts, not guilty verdicts, or what's called a hung jury. A hung jury is when the group of 12 people cannot come to a unanimous decision on a charge. Because in California, for criminal cases, every charge has to be unanimous. So all 12 people have to say guilty, or all 12 people have to say not guilty. If it's 11-1 either way, that's a hung jury. So what time we're at? We're right at 11. Sorry, I talked a lot.
No, you did great. There was one more question in the chat that somebody threw in. It says, and you can you request a police report if the victim isn't sure whether or not a police report was created?
Yes. So typically when anyone reports a crime, the officer should be giving them a police report number once it's created. If not, they absolutely have a right to go to the police agency and request the police report. Technically, the district attorney's office is not allowed to release police reports because they're not in our possession. They're the police agency's possession.
Okay.
But yeah, that's something they absolutely can do.
But the victim, like an advocate or a case manager can't request that report. The victim would have to request the report, right?
Yes, it has to be the victim.
Okay. Thank you.
Yeah.
Oh, and I knew this was going to come up. I almost asked it. Can you request the police report if the victim listed is a child?
Ooh. I would have to double check on that because I think it's.
I thought it had to be subpoenaed, right?
Yeah, because even like for say I have a case with a defendant or a victim where they were a juvenile in their case, I can't request it. I have to go through what's called a Welfare and Institutions Code 827 petition and have to ask the court to give me permission to get it.
Okay.
That's also something that's out of my wheelhouse.
Right.
I don't know too well. I just know I have to
Right.
get these records and get the request back. But because for juveniles, there's so much more protections in place, you have to get a court order for that.
Okay. And then somebody asked if there is a hung jury, what's the what do you do? Like what happens next?
So if it's a hung jury, there are several options. There can either be more negotiations for a plea deal because now the defense will have more basically in their pocket,
Right.
depending on what the split is. The case can be retried, which happens not frequently, but can happen, or you could decide to dismiss the case. Usually it's either a retrial because there's no double jeopardy because it was a hung jury, or it ends up pleading out.
Gotcha. Thank you. Any other questions folks have for Sinead while we have her? I'm not seeing anything in the chat. Well, Sinead, thank you so much for all of this information. I I've been working alongside the criminal justice system for a long time and learned things today, so I really appreciate all the information. And as I mentioned, we'll be able to send out the slides to everybody. We'll also be able to send a survey. Please feel free to fill that out. It'll take like 2 seconds of your time. And then we will have the recording of this session available on YouTube probably later today, if not on Monday. So thank you all so much. Have a lovely weekend.
Great. Thank you, everyone.